Hello, friends. Welcome to the National Constitution Center. Happy Constitution Day. We're so glad that you're here. It's so exciting to welcome you to this wonderful place. As you came in, I hope you saw the beautiful words of the First Amendment shining over Independence Hall. We have a great new exhibit on the First Amendment that I hope you can check out after you leave. And after this convocation, we're going to have Simon Tam from the band The Slants, whose challenge to an effort to stop him from using that name led to a really important case before the Supreme Court. We're really lucky right now because we've got three great judges in America, and they serve on the U.S. Court of Appeals for the Third Circuit, which is headquartered right here next to the Constitution Center. Appellate judges at the federal level are among the most important judges in our whole system. And they have different approaches to the Constitution, but they're united by defending constitutional values. And what we're going to do together is hear from them about what they think is important about their job and some of the really meaningful cases they've decided, so we can understand why it's so exciting to be celebrating the Constitution. And we're going to start with Judge Cheryl Krause. She's a very distinguished judge who's, Judge Krause, you've been so thoughtful about the importance of judicial independence and the need for judges of different perspectives, like all of you, to unite about your shared commitment to the rule of law. Tell our students about the importance of that.
Well, first, thank you, Jeff, for having us today. It is a great celebration when we celebrate our Constitution. It is, bar none, the greatest protector of rights in this world. We are the envy of other nations with our Bill of Rights and the protections that we are able to provide to our citizens. It's not perfect. We're always trying to make it better. But ultimately, the beauty of our Constitution is it secures self-governance. It secures the power of all of you for the branches that are the elected branches. That is the president, the executive branch, and the legislature, Congress, and parallel systems within your states. You choose the people who are going to govern. You govern yourselves. And as you guys get older and you get to the point of having the right to vote, that right is a precious right. Exercise it. What we do is we interpret those laws. We help with the application of those laws, trying to ensure that what the elected branches have done, the people's will, is both administered and administered within the bounds of the Constitution. And the courts in our system have the last word on that. So when we get appointed, we're appointed for life. So they pretty much make sure the people who get appointed are kind of type A people. We're going to work hard till the day we drop. The reason that we're appointed for life is for our independence. As Jeff said, we have independence from those political branches. So without worrying about currying favor with any politician, without worrying about our pay being docked, we get to make decisions that we think are the correct interpretation of the law, not based on any political agendas, based on principle. And we'll talk in a few minutes, I think, about some examples of ways that we do that in interpreting our cases. So we come from very different walks, and we were appointed by different presidents over different generations. But still, 99% of the time, we're unanimous in our decisions. And when we disagree, we do it respectfully, we do it thoughtfully, and there are cases where reasonable minds can differ. But ultimately, we're united around our mission, which is to protect and defend the Constitution of the United States.
So well said. And Judge Bibas, you were indeed appointed by a different president from Judge Krause, but you do agree in many cases and think that that civil dialogue is so important. And last year on Constitution Day, when you were here, you said something really important, which I want our students to hear again, which is that the president isn't your boss, but the law is your boss. Tell us about both of those things.
That's absolutely right. And thank you again, Jeff, and for all of you for being here. So most judges have framed on the walls the certificate, the commission, signed and sealed that says the president appointed them by and with the advice and consent of the Senate. And we look up to that. We remember what we promised to do. We promised to do justice and equal right to the poor as to the rich without fear or favor. And so it's important to keep in mind, my boss is not the president who appointed me. My boss is not the senators. They can't change their minds at this point. They do a very careful vetting on the front end to make sure that we're ready for it. But we have to be prepared to rule against them. And I had a big case involving the 2020 presidential election in which the president who had appointed me was challenging the results of the votes in Pennsylvania. And I couldn't look at what the media were saying. I couldn't look at what was being alleged. All I had to look at what had been proved in court, what people would swear to, testify to under oath. And there just weren't any charges to upset the votes of the people that had been cast. And so my responsibility was to vote to uphold the results as they had been certified by the elected election officials in Pennsylvania. And it was very interesting. So of all the things that happened after that ruling, the thing that struck me the most was my name popped up in an editorial in a Ugandan newspaper. And I don't generally read Ugandan newspapers, but it said, this is amazing. In America, a judge voted against the person who appointed him. That would never happen in our country or in most countries, frankly. And if it did, the judge would be thrown in jail. Well, that doesn't happen here. My father's an immigrant from Greece. And I can tell you in many countries, people don't expect the laws to be followed and obeyed, or they expect they have to pay a bribe or something else. We take for granted that the law works, that poor and rich people get protected by the police and by the courts, that a simple immigrant or criminal defendant or whoever can triumph over the United States government if the laws say it. And we give free lawyers to criminal defendants and other things to level the scales, just to make sure that it's not the powerful. Because in most of history, in most of countries, it's been a king or a despot or a tyrant or a monarch or a dictator or somebody else who didn't want to be bound by the laws. And in this country, we take for granted, but it's a great inheritance we have, that the laws protect all of us equally and the laws govern us. And you guys, as future voters and jurors and citizens now, you're equally protected and equally responsible for carrying that torch forward and for making sure that your voice is heard and the law continues to reflect the will of the people. Because my job, by the way, is not to fix the laws. I had a case a few years ago. Some people felt very strongly in Philadelphia that we should move to a system of giving drug addicts a safe place to inject their drugs. Other people said, no, the traditional approach we followed is, threat and punishment. Don't let anybody take drugs or assist other people in taking drugs. And Congress had passed a law in the 1980s. They amended it in the 1990s before there were safe injection sites. And our job was to read that law and say, well, does this law banning crack houses and raves, et cetera, but it didn't use those words. It just said any premises open for the purpose of facilitated drug consumption. Did that apply to ban creating a safe injection site? And people had strong political feelings. And what we said was, look, some people favor a public health model. Some people favor the criminalization model. The model that's on the books in the laws is the criminalization model. This isn't lawful under current law, but we're not saying it's good or bad. We're saying take this to Congress if you want to change the law. And so what a lot of editorial writers miss is we're not saying yay for the winners or boo for the losers.
Friends, I hope you listened to every word Judge Bibas said, because he made such an important point. In Uganda, a judge rules against the president who appointed him, he gets thrown in jail. In Russia, if you rule against President Putin, you get thrown in jail. So the difference between us and Russia and Uganda is not just a constitution. Russia has a beautiful constitution with all sorts of promises in it, but the promises are a lie because you don't have independent judges who can rule against the president. That idea of separation of powers that you're learning in school, not all the power goes to Congress, the president, or the judges, but it's separated among them, is crucial. And you need judges like the three judges who are here, who, when the president violates the law, they can say so, and the law wins. Very, very basic point. And you also talked about those election cases where you ruled against the president who appointed you. 70 judges looked at those cases, and all of them ruled that there was no election fraud. Those judges were appointed by Democrats and Republicans, and they all agreed. And it's just a really basic but important reminder of how central the rule of law and how central these judges are to our democracy. And it's great to be able to share it with you. Judge Rendell, you've done such heroic work teaching civics to kids. And you know how polarized this time is. As you listen to this discussion of the importance of judicial independence and the fact that all three of you are able to be independent against the president, what do you want our students to know?
Well, I see students here writing things. I want you to write down the word precedent, Precedent. So we say we adhere to the rule of law. And Judge Bibas says there was no basis for him to rule in a certain way. So how do we decide cases? Well, there's a thing called precedent, and that is the cases that have gone before. And we apply that precedent to the cases we have. And that provides for a certain consistency and predictability in our laws. Someone comes into court, they get a lawyer, and they say, do I have a case? And the lawyer will say, well, there is this precedent that is going to control the case. It's a case that happened before, that on similar facts, the court said this evidence is admissible, or it is not, or this privilege is recognized, but there's a predictability and a consistency, and it helps us do what we do. The rule of law is our guide, and those precedent, those cases that have gone before, help us decide what we do. When Justice Alito was being questioned to whether he should be on the Supreme Court, he said 96% of the cases he had when he was on our court were controlled by, or at least governed by, precedent. And the senators were aghast at that. But it's really true. And we are faithful to that precedent. The other thing we're faithful to is what Judge Bibas talked about, the evidence. And that's what happens in the trial courts. And you see the trial courts when you look at shows on TV. You see the judge and the evidence that's put forward. We sit as Court of Appeals, we hear from lawyers. Someone who loses in the trial court then comes to us and says, well, it was unfair what happened in the trial court, or it was fair what happened in the trial court, according to the rule of law. But in the trial courts, it's evidence that dictates. So when you watch those shows, don't worry about what the lawyers argue, worry about what the witnesses are saying. And if you're on a jury, which I hope you will be on jury service, and if your parents or relatives get asked to go to jury service, tell them they really need to serve. It's really an important duty. And the jury gets to listen to the evidence and decide whether there's evidence to support the charges. And we second guess that as well. Judge Bibas, in looking at that case that came before him, ruled based upon the evidence. There was insufficient evidence of fraud. And if that's the case, it will go that way. The plaintiff will lose if there is insufficient evidence. So I want you to pay attention to precedent and evidence. Two things that are important: evidence in the trial court and precedent both in the trial court and in our court that helps us decide what we do.
Such crucial things to think about. Great that you wrote them down. And let's now talk about precedent. Each of you on the Third Circuit have decided very important cases. In deciding them, you look at the precedents decided by your court. Sometimes they're reviewed by the US Supreme Court, which can either uphold them or reverse them. And Judge Krause, you flagged a really interesting case called Mazzo involving the First Amendment that you decided recently. Tell us about that.
Yes. So this is on our theme of elections and voting rights. So we had a case fairly recently that involved two candidates for the House of Representatives in New Jersey congressional districts. And they wanted to be on the primary ballot. New Jersey has a law that allows for primary elections for candidates to have a slogan, a 6-word slogan that can go next to their name. And the purpose of that is to allow them to identify an issue that that they're committed to, or to identify a wing of their party or some faction that they belong to, and to have that identified for voters. But if what's on that 6-word slogan is the name of a real person, or it was a New Jersey corporation, then New Jersey requires that the candidate get consent from that person or from the company to allow their name to be used in connection with that person's ballot. So here, the two candidates wanted to use slogans. For example, in Essex County, to say like Essex Democratic Committee, Inc. And that's with a real company, did not go and get consent and use this occasion to challenge the law and to say that by imposing that requirement, that it was violating the First Amendment, that it was burdening their ability to speak with the most guarded kind of speech, the speech that we protect fiercely, because it relates to what we were talking about at the very outset, self-governance. So what we call core political speech gets the very highest kind of protection. And they said this was burdening their core political speech. So that came to us, and we had to assess that challenge. They were arguing on the basis of the First Amendment. And because of what I was saying about the nature of core political speech, if it were in fact governed by the First Amendment protections, that pretty much would tell you how the case is very likely to come out. But the Constitution, in a different section, in Article 1, Section 4, and in Article 2, Section 1, also provide that states have the authority to regulate the time, place, and manner of elections. And that's important to democracy too, because without those regulations, you wouldn't have orderly, fair, reliable elections. But regulations on the election process can also put a burden on speech. So with precedent, the Supreme Court has grappled with this sort of tension. You've got really important speech, but you've also got the need to ensure that regulations are permissible. And so the Supreme Court developed a different test with precedent from a couple of cases. One, Anderson versus Celebrezzi, and the other, Burdick versus Tahashi, that apply in the situation where you're looking at something where the law is really geared to the election process, not just to what is being said, but how it's being handled as a procedural matter for the election. And that's called the Anderson-Burdick test. The Anderson-Burdick test is very different. It allows, instead of that absolute sort of protection that we give for core political speech, it's a sliding scale. It's a balancing test. So we look at what is the nature of the burden on speech, and then we look at, well, what standard is going to apply that we're going to put the state's interest to. So if it's just if it's a reasonable, non-discriminatory sort of minimal burden, then all the state has to show to be able to uphold that regulation under the Anderson-Burdick test is that it has a legitimate interest in the regulation that is imposing on that speech. So that test is a lot easier to pass. And that means that when the case that came before us was really about not just looking at the speech and deciding good policy, bad policy, or even just a matter of the First Amendment, how should we analyze it? The first question is really, which test applies? And it was after analyzing, looking at Supreme Court precedent and all the courts of appeals to pull some criteria out, come up with a standard about when the Anderson verdict test applies, that we decided that with the criteria that it involves a fundamental right, like the right to speak or assemble or to vote on the one hand, and then the second criteria being that its main purpose, its primary goal for this regulation was for the election process, not about the content of the speech or regulating the speech, but the purpose was really securing the integrity of the election. We decided Anderson verdict applied here, and that this was, then we had to actually apply the Anderson verdict test itself, and concluded that this law was not based on content and not based on viewpoint. It applied to any candidate. Didn't matter what message they were putting out there. They had to get consent for a name or company. And the reason was that the state wanted to ensure that people weren't confused. They weren't misled by somebody putting a slogan with a name of a company or the name of some cause that in fact they weren't associated with at all, and that they were just using somebody's name as a sort of a ploy in elections. So we upheld the law, and the plaintiffs here have petitioned the United States Supreme Court. It is a case that's gotten a lot of attention, and briefs that have been filed in the Supreme Court suggesting that the court should take up the case. Many amici, friends of the court briefs from different organizations, asking the court to give some more clarity to when the Anderson verdict test applies. Were we right with the test that we came up with for when it applies? And how do we define when speech is neutral on the basis of content and neutral on the basis of viewpoint? So those are things you can tell. We can't just look to the text of the Constitution. We've got different rights, and sometimes they're in tension with each other. We have to look to things like Supreme Court precedent, history, but also how it functions, also to some considerations about the actual consequences of interpreting the law one way or another.
That was so clearly explained, and it's such an important case. And I'm just going to repeat some of it again to make sure I have it in my mind. And as you listen to the judge, I know you'll want to repeat it too. So the judge says this really important case says, if I want to run for office and put on the ballot next to my name, Jeff, a slogan like Black Lives Matter or Make America Great Again, I can't do that without getting permission from the Black Lives Matter organization or from whoever owns MAGA. And the question is, does that violate my free speech rights? And the judge said she first had to decide whether it's a time, place, or manner regulation. And there was this precedent that Judge Rendell mentioned called the Anderson verdict test. And since the purpose of the regulation was to regulate the election process and not to suppress my speech, the court decided that that new test did apply. And since there was a legitimate reason for making me get the permission, then I could do it. It took a while for the judge to explain her reasoning to you, also in her incredibly clear opinion, which you can read online and is really worth your reading. But you see that the First Amendment is complicated. It requires a balancing of precedents of different values, all guided by the rule of law. So you just got a wonderful introduction to the First Amendment and the way judges think. Judge Bibas, I think you flagged another important Third Circuit case involved. It's called Sachs versus State College School District. Tell us about that case and why you.
Right, so Justice Alito, thank you, Justice Alito used to be a judge on the Third Circuit for 15 years, and now he's been on the Supreme Court for about 17 years. And he had a case involving some school children, and they came from a religious background, and they thought that kind of a traditional approach to no sexuality outside of marriage and a more traditional approach, and the people in the school district, I think, were more LGBT friendly. And so they said, well, we want to witness to our faith here. And so you get these interesting issues of what are school children free to say on campus? And this has come up over and over again. So this starts with the Tinker line of cases, where there's Mary Beth Tinker protesting the Vietnam War. She's allowed to wear a black armband to school as long as it doesn't cause substantial disruption. You don't lose your rights at the schoolhouse gate. Well, the court has some other cases. They have a case that says, well, if there's speech that's encouraging drug use at school, that seems like that's a legitimate thing for the school to have an interest in. It's illegal, they're taking care of young people, but generally, school children don't lose their speech rights unless it causes a major disruption. There are cases involving school newspapers and things like that, where again, the school kids get to say it. Well, what happens when you get someone who has maybe a conservative Christian approach to human sexuality, and then the people in charge of the school maybe are concerned that it might antagonize some people who are maybe more LGBT friendly or something like that? And so Justice Alito wrote an opinion saying, well, the school, we don't just let the school administrators shut down whatever they want. They have to be able to point to specific disruption that's going to come if they speak. And you can't just say, well, we're generally afraid of this, or we just label it harassment. There's not a general harassment exception of the First Amendment. You have to point to specific problems that are going to happen. And even in school, where we give a little more leeway to the principals and the teachers, generally, the students get to speak their minds. And the follow-on case to that I thought was really interesting was one that Judge Krause wrote the Third Circuit opinion on, and that I had the privilege of being on. It ultimately went up to the Supreme Court. You might have heard of the cussing cheerleader case. So this was, Brandy Levy she started out as a high school freshman in Mahanoy, and she wanted to make the cheerleading team. And she went out for it, but she only got on the junior varsity squad. And they said, oh, come on, try again next year. When you're a sophomore, surely you'll make the varsity squad. So she went out again, but she only made junior varsity. But this other girl who was a freshman made varsity. Well, she was not very happy. So Brandy and her friends went to, I guess the local equivalent of the Wawa is the Cocoa Hut, right? It's the convenience store. So on a Saturday afternoon, she goes with her smartphone and she Snapchats out something. Now, by the way, how many of you think Snapchat is secret and private and it's just going to go away? Don't be silly like that. Brandy thought, oh, just me and 200 of my closest friends are going to see it and then it's going to go away. No. So she sends out a snap, and the snap says, F you, F coach, F everything, and the school. So bad words. And one of the people she sends it to is one of her 200 friends, is the daughter of the cheerleading coach. So the daughter takes a screenshot, shows it to the coach. Brandy gets suspended, okay? And they say to her, hey, you signed these rules that said you're gonna be like, represent cheer properly. And she said, but it was on a Saturday afternoon at the Cocoa Hut on my personal account, not on the school stuff. You don't get to censor me. Well, she sued the school. They tried to suspend her from cheer. She sued the school, and the trial judge said, that doesn't look like it was very disruptive. And it came up on appeal to us, and we were thinking that Tinker precedent was a shield for students in on-campus speech. Now, there hadn't been a lot of precedent about what happens for social media, because that really grew up in the last 15 years. But people were turning it from a shield for on-campus speech into, here's a sword we can use to shut down off-campus speech that might affect people on campus, because it's reaching teachers, it's reaching students, they're going to gossip in the hallways. And so we proposed that the best way to read that precedent was that is just about on-campus speech. And if it's off-school time and off-school premises and off-school hours and off-school devices and off-school computing resources, then you can't, the only arguments you can use to restrict a student's free speech are the same ones you could use to restrict an adult's free speech, like threats of violence or stealing intellectual property if you stole exam answers or something. But you can't just say students have to shut up about the schools. Criticizing the principal and the teacher and the cheer is like, that's kind of a part of a democracy. And so it went up to the Supreme Court, and there wasn't much precedent in this area. The Supreme Court did not adopt as clear a rule as Judge Krause had proposed and I signed on to, but they leaned in that direction. And they said it is at least very important that this was off-school premises and off-school time. And you can't just treat yourself, the principal, as having the same power over schools, the students off campus as on. So the moral of the story of Tinker and Sachs is students have a lot of free speech rights while they're in school, but they still retain even more off school. And the courts will look carefully to make sure the principals and the teachers aren't abusing their authority beyond what they need to protect the educational environment.
Beautiful. Friends, isn't this exciting? We're finding out all the case law governing speech in school, which directly affects your rights. And you just heard a bunch of really important precedents that were mentioned. Judge Bibas mentioned the Tinker case. Mary Beth Tinker wearing a black armband to protest the Vietnam War in school. The Supreme Court says she's allowed to do that, even though the school wanted to punish her. When you leave, go into the new First Amendment exhibit, which we just opened last week, and you'll see Mary Beth Tinker's actual armband, because Mary Beth Tinker loaned it to us so that it could inspire you in the exhibit. And Mary Beth Tinker is going to appear for a virtual town hall with us later today, and you can talk about it. And then you just heard that the leading Supreme Court precedent about what you're allowed to say online on your spare time is called this Mahanoy case, the BL case. Judge Krause wrote the lower court opinion. The US Supreme Court basically agreed with her and Judge Bibas, although they were not quite as crisp in saying that if speech takes place on off-school time on your own social media accounts, it should generally be highly protected. And the test, which comes from Tinker, is if the speech is likely to cause a substantial disruption in school, then you can regulate it. But if it isn't, it isn't. And now all the judges are working out the lines. What's a substantial disruption? Do you have to intend it? What happens if you're at home and not at school? All these really complicated questions. Judge Rendell, you wrote a concurrence in the Sachs case involving that anti-harassment policy. Tell us about that, and if you would, because you're such a great teacher on school speech. After Mahanoy and the Supreme Court said there basically is protection for speech on social media. What's the state of the First Amendment in schools now?
Well, Jeff, I wanted to comment on that because I think it's really difficult for schools to figure out what to do in the heat of the moment. We have the cheerleader, and she does this on a weekend, and they're confronted with it on a Monday. The kids are talking about it. What is the school to do? Well, they call their lawyer. And what does the lawyer say? The lawyer says, well, it depends. What do you mean it depends? Was it private? Was it this? Was it there? There's all these multi-factor tests. And sometimes, I mean, people say, why do you write opinions the way you do? And sometimes we write them to offer guidance to people about how to act in situations. And I think Judge Krause's opinion in this case for our court, before it went up to the Supreme Court, really offered some guidance to schools. Listen, unless it's an egregious situation, if it's off campus, hands off. And that would have been an easy thing to do, to say, okay, this wasn't that egregious, because the Supreme Court agreed with us as to the outcome, that she shouldn't have been suspended because it wasn't that egregious. So we were giving guidance, unless it's really something that's off the charts, if you will, leave it to the parents, basically, leave it to someone else to decide. You, public school, you're not going to encroach on the home environment or the environment in front of the convenience store, et cetera. So what did the Supreme Court do? Justice Breyer, love Justice Breyer, he's wonderful. He reinstates this well, it depends. If it's this, or if it's this, or if it's this, it turns out that in this situation, all of the factors pointed towards her not being suspended. It was ostensibly private, to her on her private cell phone, to a private group. It was vulgar, but she was expressing her view about a subject in the community. All of the things that you would tick off favored her. But the next time, what if 3 of the 5 factors favor her? What if 2 of the 5 factors? I feel sorry for school administrators. I mean, students do have the right that isn't shed on the steps of the, the school gate, if you will. But then again, shouldn't the school have something to say about what is disruptive to the school mission? What if kids are all talking in the hall and they can't get through, a session without this coming up and distracting from the social studies and distracting from everything else? So unfortunately, our clarity has gone the way of all flesh. And according to the Supreme Court, it's still an it depends situation. And that's where I come from, that I feel kind of sorry for the school administrators who have to put up with this. And Justice Alito, in the case involving the drug, where the analysis was this speech by the student promoted illegal drug use, and we're not going to allow that. Justice Alito had a concurrence saying, okay, but these special characteristics, are few and far between. We're not going to say that schools are in loco parentis. We're not going to say that they have just an educational mission. We have to recognize that students do have rights that we're going to uphold. And I thought it was kind of an interesting concurrence on his part. Now, it was a concurrence, and that means when we write opinions, there's the majority. And then if someone wants to disagree totally as to the outcome, which would have happened here if the Supreme Court reversed us, they'd write a dissent and say, I disagree with what you said. If they agree with the majority opinion, but they want to add something else to it, or put a point of emphasis, or maybe say, I agree, but this precedent should be overturned, they'll write a concurrence, which agrees, but adds something extra. And sometimes a concurrence could be really useful. Very often, we will write a concurrence in a case when a precedent is established, but we think the Supreme Court maybe should take another look at it. So we can write a concurrence saying, I agree, because that's what precedence dictates. But you know what? In this day and age, that precedent needs to be, the Supreme Court should look at this again. So I thought it was an interesting concurrence on his part.
So interesting to learn from Judge Rendell. We're talking about these different precedents. Judge Krause had one approach and the Supreme Court had another one. Judge Krause had a really firm rule: off-campus speech is protected and on-campus speech might be regulated. And the Supreme Court with Justice Breyer preferred this standard, looking at lots of complicated factors. They came out in the same place, protecting the cheerleader's speech and her ability to use those words on Snapchat, but for different reasons. All right, we just have time for a few final thoughts in this great discussion. You're just getting insight on the First Amendment from the judges who are shaping it for our whole country. I do hope you can go see the First Amendment gallery before you leave. And at the beginning of the gallery, there are 2 great documents by Thomas Jefferson and Louis Brandeis that set forth 4 reasons for protecting freedom of speech. First, freedom of speech is necessary for democratic self-government. Second, it's necessary for holding public officials to account. Third, it's necessary for the discovery and spread of truth. And fourth, it's necessary because speech and conscience and our freedom of opinion are natural rights that come to us from God or nature. They're not given by government. And I can't tell you or you what to think because your opinions are the product of your reason. And you can't give me your reason because it's inherent in who you are as a human being. So Judge Krause, final thoughts to inspire our students, but in his Mahanoy opinion, Justice Breyer emphasized that democratic aspect of public schools as nurseries of democracy. Why do you think it's important to protect free speech for students? And what do you want our students to think about as they continue to learn about free speech?
As I said at the outset, you are the future leaders. You are the ones who are going to guard this democracy if we can keep it, if we can ensure that the rights that we have survive through different presidencies, through the challenges of social media and changing technology, through even changing norms. So for you to exercise your First Amendment right and learn about your First Amendment right in school, it's absolutely crucial. My husband is in the military, and interestingly, we take the same oath of office. We are swearing to protect and defend the Constitution of the United States. We do it with our pen. There are people out there who are doing it with their lives. People sacrifice their lives to protect these rights so you can exercise these rights, to think, to be creative, to make sure that America stays this, the world's heart, the crucible of innovation. And your embracing of those rights and participating in this democracy is absolutely essential. So I encourage you to continue learning about that right and the many other rights that as you walk through this amazing center, you will learn about.
Could I just piggyback? As a closing thought, you have legal rights to speak, but the framers always understood that it piggybacked on a culture of free expression, that we expect people to thicken their skins a little bit. We expect them to listen to things that they don't like, maybe they're not comfortable with. We expect them to do it in a spirit of, these are my fellow citizens. And they're not, sometimes people can be kind of rude and stuff, but we can shrug some of that off and get past the shrillest, loudest voices. Try to engage with people with a presumption of good faith and to listen to them. Doesn't mean you're always going to disagree. Maybe sometimes you'll be convinced. Even when you're not convinced, our democracy depends on people coming together and being able to compromise or understand where they come together. And one of the most inspiring things, even though I'm normally a Court of Appeals judge, I've presided over a few jury trials too. And listening to 12, at the end of the case, I go in and talk to them if they're willing. These people from very different walks of life, they're talking, they're listening. This person had this point, this person had that point. Even though we come from very different races, ethnicities, wealth, jobs, backgrounds, they realize we're all citizens and we can all dialogue and we can all come to a better understanding of the truth, a more perfect union of thought. And so it's not just a legal right, it's a culture of recognizing and respecting your fellow citizens and their points of view. And so, go forth and do that. We courts, we protect your right to do it, but do it responsibly and productively so that you're not just shouted down by the loudest or most extreme people, but you listen and you research past that.
Wonderful. Judge Rendell, last word to you.
Well, the expression by every person of their views is what democracy is all about. And that I get back to the issue of jury service and voting. If we cede power to the few by not voting, we're not really a democracy. In the 2020 election, 66% of eligible voters actually voted. We say that's an all-time high. But that means that 1/3 of the eligible voters in this country did not express a viewpoint. And if we're a democracy, that expression, that speech of this is my view and this is what I believe, that's key, that every person express that view. And as Cheryl said, it's the essence of America. I mean, it is the First Amendment, after all, the free speech, religion, the press. So these are the things we value. We want people's views and their beliefs to be heard. And we value that. And I wish that more people would value the fact that they want to express their view as to who should lead this country. Because the people who lead this country, obviously they're in the executive and the legislature. They also determine who the judges are. So you have a voice in that. So I would urge you to use that voice, to express your views, to use the First Amendment in the way it was intended, and share your views with others, hopefully in a way that's civil discourse, which is kind of rare these days. But to the extent you can contribute to civil discourse, you're contributing to our democracy.
Superb. Friends, thank you so much for learning about the Constitution, and please join me in thanking our judges.